Good afternoon, ladies and gentlemen. Thank you very much for joining us in today's event. A couple of months before the end of the grace period, the Embassy of Greece in London, in cooperation with the delegation of the European Union to the UK, is organizing this online information session for Greek citizens in the UK on the EU settlement scheme. My name is Konstantinos Adamopoulos. I'm the head of the Consular office of our embassy in London. It is my pleasure to introduce Mr. Christopher Benn, immigration lawyer and special advisor to the European Union in the UK. Chris has over 12 years of experience in immigration law. He is accredited as a senior case worker and supervisor under the Immigration and Asylum Accreditation Scheme. Chris has a master's in HR law from Essex University. He is an experienced welfare lawyer and works internationally on refugee issues. Chris will give a presentation on the EU settlement scheme and answer questions. Our session forms part of the events organized by the Embassy in the occasion of our National Day. Let me give you, first of all, some brief statistics concerning the EU settlement scheme. Over 5.1 million applications have been made to the EU settlement scheme, according to the latest statistics, with just over 3 months to go before the 30 June deadline. Concerning Greece, 1,010 applications have been concluded, of which around 39,000 have received settled status and 69 pre-settled status. Following Chris's presentation, you can make your questions to the Q&A bar and the chat bar, and Chris will provide answers. And now I give the floor to Chris. Chris.
Thank you very much, Konstantinos, and thank you to the Greek Embassy for inviting me to speak this afternoon, and obviously thank you to everyone who's joining the session with us this afternoon. Hopefully it will provide some sort of helpful information to you wherever you are in the process, because I think, as has already been said, we have had a lot of applications to the settlement scheme so far. It has been lots of uptake, lots of applications, and the vast majority of them have been granted status under the scheme. So there's a lot of positives that we can take from what has been done so far. And I'm sure people today, from the questions I've received in advance, I can see that people have already applied to the scheme for their own status. But of course, there are probably still people out there who do need to apply, and they do need to make sure that they do so before the 30th of June, because what we want to avoid is people missing the deadline, because, as I will explain in a bit more detail, it can be very problematic to miss the deadline for the application, even though there is a process in place for people to apply late. We would very much rather people didn't do that. We'd rather that they all got their applications in by 30th of June. So what I will do first of all, before we move to the Q&A section, is to just run through a presentation that I have about the scheme. It will just cover the application method, the actual way in which people apply, and I will point out some of the aspects which I think are crucial for people to understand, because they're common questions. I'll also try to cover some of the issues that I've been made aware of before the session, to do with things like what is qualifying residence and how long people are allowed to be outside the UK, because I think it's something that is has been asked. That it would have been a question anyway, but I think in light of the pandemic and the last 12 months, people's lives have been very much turned upside down in terms of being outside the UK. And so I'll cover that and how that interacts with the scheme and the conditions. So I'm just going to move to share my screen, and I will hopefully, sorry. So yeah, so as I say, I'm happy to make the slides available. Obviously the session is being recorded, and so no one needs to worry about everything that's written down. I'll run through the main information, but we can circulate the information as well. So the background to the settlement scheme, we obviously are all very familiar with Brexit by now, and the key legal change as far as residency in the UK goes for European citizens is that free movement law ended on by the 1st of January 2021. So essentially that idea that European citizens can move freely to the UK, that ceased on the 1st of January. And for citizens who aren't already living in the UK, that means that if they want to come to visit the UK, to study, to work here, they have to come under the UK's domestic immigration system. They cannot use free movement law anymore. But what the purpose of the withdrawal agreement that was agreed between the UK and the EU towards the end of 2019, so not the trade agreement that we heard about before Christmas, we're talking about the withdrawal agreement, which was agreed a year earlier in 2019. What that does is that preserves the rights of EU citizens who are already living in the UK and those who lived here by 31st of December 2020. So the idea was that if you already made your life in the UK, your residence here, then you shouldn't be forced to sort of change things because of the outcome of Brexit. So that's what the withdrawal agreement says, and there are lots of rights for citizens in the withdrawal agreement. And the main set of rights, or an important set of rights within the withdrawal agreement, is to be able to remain living in the UK, to be resident here, and to be able to be resident here for a permanent basis or on an indefinite basis, if that's what you choose. And so what the UK government has done to create the domestic legislation to create the rights that the withdrawal agreement provides for European citizens is to create the EU settlement scheme, the EUSS, as we sometimes call it. And so what we have with the EUSS is an application process, and it is a required application process. The withdrawal agreement allowed the UK to create a process that people had to apply to in order so that the UK can issue status to people under the scheme. And so when someone applies to the settlement scheme, they're applying for one of two statuses, either settled status or pre-settled status. And the distinction between those two statuses is based on how long the person who applying has lived in the UK for. And broadly speaking, it is if you have lived in the UK for 5 years when you apply, you will be given settled status. And if you haven't lived here for 5 years when you make the application, you're given pre-settled status. And so there are some exceptions to that, some limited exceptions, like sometimes children will be given settled status without living in the UK for 5 years because the parent has been given settled status. So there are some exceptions. It's not always the case that it's 5 years of residence, but the broad rule is that is the distinction between pre-settled status and settled status. It's important to remember, and I will cover it again later on, is that if you are granted pre-settled status, the Home Office expects you to make a second application for settled status in the future once you have crossed over the 5 years of living in the UK. So what you would do is you would make your first application for pre-settled status now, and then once you've lived in the UK for 5 years, whenever that point comes, if you've already lived here for 4 years, then what you do one more year, and then you can apply again and you'll be granted settled status. So you have to upgrade, convert the status, however you want to call it. You must make a second application, because otherwise, if you let the pre-settled status expire, you'll lose your lawful right of residence. And again, we don't want anyone to go through that. The two deadlines that are very important for the scheme, there's the 31st of December 2020, which has passed, because that's the cutoff date for people to be living in the UK. If you didn't live in the UK by that date, then you can't apply under the scheme unless you're a family member who's joining someone who has status under the scheme. And I'll talk about family members again in a next part of the presentation. So we've passed the residency deadline, and where we are now is we're coming up 3 months to go, basically, till we get to the application deadline. And that is obviously for those people who haven't yet got a status in place, to make sure that they do make their applications to the Home Office. It is important to know who does need to apply, and that there are some limited exceptions to the requirement for people to apply, because there are some people who don't need to, and I'll just cover who that might be, because it certainly will affect some citizens, particularly those who've lived in the UK for a longer period of time. So the general rule, the way to think of it, is to assume that you do need to apply. And even if you have something called a European Permanent Residence Card, which is like a blue document about that big, even if you have one of those documents, you do still need to apply to the scheme. And if you have a family member who's not from the EU themselves, and even if they have a residence card that was issued under EU free movement law, they also do need to apply to the scheme, because what you're doing is changing your status from the free movement law status to status under the immigration scheme, under the settlement scheme. So you do need to apply if you already have those documents. If you have something called indefinite leave to remain, which is an immigration status that's issued by the UK, then you don't need to apply to the scheme. Indefinite leave to remain tends to be issued if you're a European citizen and you have indefinite leave to remain. That probably means that you've lived here a long time, or you were living here perhaps before your country joined the EU themselves, because it's a domestic immigration status. And what happened was that if you were granted that status and then the UK joined the European community, or your country joins the EU, then you have free movement rights as well, but you never lost. In most cases, you wouldn't have lost your indefinite leave to remain. And so you can rely on that to show that you are allowed to live in the UK lawfully. Now, if you have indefinite leave to remain, you can also apply to the scheme. There's nothing that stops you applying to the scheme. And my personal point of view would be, I would encourage people to do so for a couple of reasons. Firstly, it gives you status under the scheme is actually better than indefinite leave to remain that was issued many years ago. It's a better type of indefinite leave to remain, settled status. So that's one reason. And the other reason is because settled status is digital, it's not something that you would lose in the same way that you could lose an old passport which has an indefinite leave to remain stamp in it. Because if people lose documents with old stamps in it, it becomes very hard to prove that you may have been granted in the past. And so it's just a way of updating your records to show that you've got status in the UK, and it's digital, so it can be accessed at any time. So those are two reasons, but you don't have to apply in that situation. If you're someone who has become British as well as holding your Greek nationality, or if you happen to be born with Greek nationality and British nationality, then you don't need to apply, or you cannot apply to the scheme, in fact, because your British nationality is your right to live in the UK. So the scheme doesn't let you apply in that situation. But if you have family members who you need to sponsor under the scheme, you can still sponsor family members as a dual Greek-British citizen. But it is a bit more of a complicated process that you have to go through. So sometimes you need to talk to someone who understands the sort of the legal aspect if you're sponsoring family members. Irish citizens don't need to apply to the scheme because there's an agreement between the UK and Ireland that pre-exists the EU. So they're not a nationality they can apply, but they don't have to. They're the only European nationality who sort of has a choice about whether to apply or not. Children is often something I'm asked about, because when people have children born in the UK, sometimes they think, well, that child must be born British because it's born on British soil, which is not exactly it's not the correct legal position. Sometimes the child is British when they're born in the UK, but it's not always the case that they would definitely be British. It does depend on the situation of the parents when the child is born. So if you have children who are born in the UK, please don't assume that they don't need to apply, because they may need to. You'll need to understand whether or not they were born British. If they were born British, they can apply for a passport. But if they weren't born British, then they need to be making an application, and it's a separate application to the parent's application. You can link the application to your own if you're the parent. You can put in the reference number of your application, but the child does have to make a separate application to be granted status as an individual. Okay, so it's very important, because we think children is a category where there may be people might not always understand they need to apply, and if they don't apply, then they'll have to make a late application, which of course, as I've said, is a bit trickier. So just to cover family members, because it is an important part of the scheme, and it's particularly important now that we've moved past the 31st of December 2020, because if you yourself, if you hold status under the scheme, and you have a family member who, for whatever reason, wasn't able to come to the UK before 31st of December, then you may be able to sponsor them to join you under the settlement scheme, which means that they could come and live with you in the UK. They have a free application process, and all you really need to do is to prove that you have a relationship with that person. So there are some family relationships which I've set out there, which is your spouse, civil partners. Durable partners means like unmarried partners, but in a serious relationship. And then you have children who are covered by the scheme. And if the child is over 21, they can still apply if they are considered to be dependent on you as the main sponsor. And you can also apply for dependent parents and dependent grandparents to join you. So dependent means, it does have a meaning. It means that they need to rely on you for some aspect of their life. Is it financial? Is it to do with their health? So there is an element with dependent parents that you have to show something a bit extra. With a spouse, a civil partner, or an unmarried partner, it's very important that the relationship existed by 31st of December 2020. So if someone was married today, if they got married today, then in theory that they couldn't sponsor the new spouse under the scheme because the marriage took place after the 31st of December 2020. There's you may be able to argue that before or by the 31st of December you're an unmarried partner and then you've gone on to become married, but it's a more tricky application to make. So it's really important to know that the relationship is supposed to have existed by the end of December 2020, unless you're a child. If your child is born in the future, they're always eligible to be sponsored under the scheme. Okay. If you have a family member who you're sponsoring, if they're not in the UK at the moment, or and if they've not lived with you in the UK before December 2020, it's very important to know that they have to apply to join you. They can't come into the UK as a visitor and then apply whilst they're in the UK as a visitor, because the rules are written in a way that doesn't allow that to happen. So they have to apply outside the UK under the scheme. That they can either apply for status under the scheme or they can apply for something called a family permit, and then they're granted the right of entry to join you as their sponsor in the UK. So it's important to follow that process, because if you don't follow that process and they come in as a visitor and then they try to apply, the Home Office will refuse it and they'll tell them to go back and apply to come in the proper procedural way. Okay. If your family member was living with you before in the UK before the end of December, they just apply into the scheme in the normal way. They make an application by 30th of June. So you do have two categories of family member, and it's important to know which one you're sponsoring, as the process is different. So when you're coming to apply to the scheme, hopefully it's straightforward for you. And in many cases, it is straightforward for people. I wouldn't pretend that there are no difficult cases or complex cases under the scheme, because there are some very complicated cases. But you can see from the fact that there's been so many millions of grants of status that a lot of people, it has been quite straightforward for them to do it. So hopefully that's, your situation will be nice and straightforward to get the status. So when you apply, you essentially have to prove three things. If you're a Greek citizen, you'll be proving three things. If you're a family member who needs to be sponsored, you have to prove a fourth thing. But for most European citizens, it's three things. It's prove your identity, show that you've been living in the UK before the 31st of December 2020. And if you're applying for settled status, show that you've lived in the UK for 5 years when you apply. And the final part is a criminal background declaration about any convictions. And as I said, if you are a family member who's being sponsored by someone with status under the scheme, you have to show that you have the relationship to your sponsor. If that's a married couple, then you put forward the marriage certificate with the application. That's the proof that you are in a qualifying relationship. Most people make the application online. And because the Home Office really wants you to apply online, there are some paper application forms, but it's quite difficult to get them from the Home Office. So generally, you need to try to apply online if possible. And to make the identity, the proving your identity more straightforward, the Home Office created an app that scans a chip. If you have a passport with a biometric chip in it, the phone app that the Home Office developed can scan that, and it can send the information to the Home Office, and then it puts the information into your online application form for you. And it's generally the easiest way to do that if you do have a passport that can be scanned. So we would encourage people to do that. You don't have to use your own phone. You can borrow someone's phone to do it. It will still work. So that's essentially, if you can't use the app for some reason, then you can send your document to the Home Office. They will check it, they'll take a copy of it, and then they'll send it back to you. So that's the other option. I'll just come back to this because I think something that's really important about coming towards the end of the period to apply, so as we come up to June, is that some people their passports will expire, or their national ID cards, which you can also use to show your identity, they might expire. And if a document is expired, then you can't use the scanning app because the phone says, oh, well, it's expired. You can't use that document. So the Home Office, what they really want you to do is get a new document, essentially renew your document before you make an application. But I think something that will become an issue, and this is something that will happen for every country, is that there's a process involved in getting a new document, getting a new passport. It takes time. And so at some point, people are not going to have enough time to get a new passport before the deadline to apply passes. So if you think that that's going to affect you, if you're not sure you can get a new document, what you have to do is you have to call up the Home Office. And I've put the number at the end of this presentation. And you have to ask the Home Office to give you a paper application form. And they'll say, why do you need a paper application form? And what you have to say to them is, well, I cannot get, I've got a passport, but it expired and I haven't been able to renew the passport, and I'm not going to be able to before the 30th of June. So I need to apply using my expired document. And the idea is that the Home Office should then send a paper application form so that you can make your application that way. I say that's what should happen, is because I have to warn people that sometimes the Home Office call center doesn't want people to use an expired document. Really, they want you to try and get a new document before you apply, so you can use the scanning process. But it's just not going to be possible in some cases for people. And it's really important that people are allowed to use the paper application form to apply with an expired document so that they can get their application done in time. So it's just a little heads up, because we're three months away, so people might not be able to get that document renewed. Okay, so that's the ID, proving the identity, proving you have a nationality of a European member state. Then you move to how long have you been living in the UK? And that question is so. The first thing to know is that this period of residency in the UK, it has a specific name under the scheme. It is called your continuous qualifying period, or continuous residence. Sometimes people call it that. And what it's very important to understand about continuous residence is that it begins once you move to the UK. So whenever you move to the UK, your continuous residence has begun. So if that was sort of in sometime in 2020, that's when it began. If it was 5 years ago, it began 5 years ago. If you moved to the UK 30 years ago, then that's really when your continuous residence began for the purpose of the scheme. So it just depends on your own circumstances. And as I said, if you're applying for settled status, then you have to have those 5 years of continuous residence. So if you're applying today, you would need to go back to March 2016. And if you lived in the UK from March 2016 or sometime before that, you would have the 5 years that you need to get settled status. If you've come in the last 5 years, you know that you're applying for pre-settled status. So that's fine. You understand that that's going to be your application. But what's really important, and I will clarify this in a couple of slides' time, is about what does continuous residence mean? Like, is it how much time do I spend in the UK to be considered to be resident? Because that's very important in your 5 years of qualifying, that you're considered to be here for a long enough period of time in every year to be considered resident. I will come back to that in a second when I've just talked a little bit about how you prove that you've been resident, because this is the part. It's one thing you will know from your own situation how long you've lived in the UK, but the Home Office also wants you to prove how long you've lived in the UK, or it wants you to prove that you've got 5 years if that's what you're showing. So what happens is the form asks you for your national insurance number. If you have one, give the national insurance number. If you've been working and you've been living and working in the UK, the national insurance number will probably show you as being resident, because it just shows that you've been making national insurance contributions. It looks at the last 7 years. It doesn't go back beyond 7 years for some reason, but it will show the last 7 years. And also, if you've received any benefits from the Department of Work and Pensions, if you receive a state pension, it will also see that by checking the national insurance number. So the idea of that is that it's looking for the easiest way to help you show that you've been living here. It's not trying to check whether or not you've made a benefits claim. It's not interested in that, the system. It just wants to know, can we see the person living in here in the UK from the national insurance number? If you don't have a national insurance number, it doesn't matter. If you do have a national insurance number, but you haven't been working and it hasn't been active, it still doesn't matter, because what happens next is the online form will say to you, well, we can't see you being resident in the UK, or we can't see you for 5 years, because it always checks for 5 years first. Would you like to give us some documents to show that you've been resident? And that's the way that you can also prove that you've been living here. You can upload scanned copies of residency evidence. And the Home Office has a list of evidence that they say is a good way of showing that you're resident here. It's not an exhaustive list. So if you have something that's not on the list, that doesn't mean you can't use it. It just means the Home Office list is just the most obvious things that they can think of. And again, there's a link to that list of residency evidence at the end of the presentation. And the idea is, it's things like council tax bills, it's like bank statements. If you do have working documents, but for some reason you didn't show up on the automatic national insurance check, use your P60, use your wage slips. So things like that, and if you've been studying, like letters from the university, enrollment, degree certificates and things like that. So there's lots of different ways to show that you've been resident. And the idea is that whatever your situation is, you can show that. And so you scan the documents at the point when you're applying. And when you submit your application, if the Home Office wants to see more information, they will write to you and ask you for more documents. That's what commonly happens, is they say, oh, can we have some more evidence of your residence? And then you can email it to them, or you can upload more documents to your application. So that's how you prove your residency. But what you need to come back to the question on what is residency, what does continuous residency mean? It basically means, if you look at your 5 years, if you're applying for settled status, then in the last 5 years, or the 5 years that you're using, you don't have to use the last 5 years. You can use an older 5-year period if you want, but you have to have been in the UK for at least 6 months in each 12 months of your residency. If you've been outside for more than 6 months, then basically European, because this is all based on European law, and what that said, what free movement law said was, well, that's not your principal residence, and therefore you're not considered to be resident there, because you're spending more time away from that country than you are in the member state. So you've got a minimum of 6 months in each 12 months. Now, sometimes I get asked, well, what does 12 months mean? Is it January to December? Is it a calendar 12 months? If I came in June, does my 12 months go from June to June? Or is it something else? And unfortunately, the answer is that there's a bit of a disagreement about what the 12-month period is, because the Home Office will say in their rules that what they say is it's a moving 12-month period. So we look at any 12-month period, and if the person has been away for more than 6 months, then that would break the residency. So basically, they would say is, if you had like 3 months away from the UK at the end of 2019, and then 4 months away at the beginning of 2020, they'd add those two together and say, well, you've got 7 months there, so that's breaking it. So they always look at 12-month period as a moving thing. The European Commission has a different interpretation. They say, well, actually, it's a static 12 months, which begins when you move to move to the UK. So if your absences fall within If you come on the 1st of January, then you have the 1st of January to the 31st of December. And then your next absence in January of the following year is a new year, that you're starting all over again. So there's a difference of interpretation there, I'm afraid. The problem with differences of interpretation is that initially what will happen is the Home Office will apply their interpretation, and it will need to change, probably through cases and cases and litigation, if it's going to be changed. So that's just something to be aware of. I'm afraid I can't give you any more kind of concrete way in which it will ultimately be decided, but just to say that sometimes there are disagreements about how things are interpreted, and that's one of the things in the scheme. So you have to look, it only matters if you think you've been absent for more than 12 months more than 6 months in a 12-month period. If you've been here, and like most people, if you're living and working here, you're not going to be anywhere near to that, because you would never have been away for nearly 6 months in any year. It's more if you're retired, or your life means that you spend a lot of time away, that you'd have to think about that. And it's also important to remember that there is like an exceptions clause in there, and what that says is that you're allowed one period in your 5 years. If you're looking at a 5-year qualifying period for settled status, normally it's you have to be resident for 6 months in every 12 months. But you can have one period where you have a single extended absence of up to 12 months if you can show it's for an important reason. And the examples of the important reason are given in the slide there. It's things like childbirth, serious illness, studying abroad. If you're at university in the UK and then you do a year overseas at another university, you're allowed to have up to 1 year studying away and come back to the UK, carry on your studies, and you haven't broken your residency. So you're allowed one of those absences, but it has to be for an important reason. It can't be just because you choose to have an absence of like up to, say, I want to be away for 10 months and then come back. It doesn't work like that. It has to be for an important reason. And the last point on the bottom there is probably quite important, which is if anyone has to do compulsory military service, all of that time is allowed outside the UK. It doesn't matter how long it is. You will not break your residency if that's the reason why you've been away for a long period. So that's the rules on continuous residence. They can be very confusing, I'm afraid to say. They're not always straightforward. And also what's happened in the last 12 months is that we've had a health pandemic that no one has ever really experienced before in their lifetimes. And so what has changed, or what's happened because of that, which probably would not have happened if this situation hadn't arisen, is lots of people have been away from the UK for longer periods than they would have intended to be. Now, sometimes because of employment issues, lots of people unfortunately have lost their employment, and maybe they went home to their home country for a period of time, not because they wanted to leave, but just to sort of see what the situation happens, sort of works out, and then come back when things get better. Some people have got family who they wanted to spend time with. Some people wanted to leave the UK because there was a very high infection rate in the UK, as we know. So there's lots of different reasons why people might have had a longer absence from the UK connected to COVID-19. So what the Home Office has done is created a guidance document to say how they will look at an extended absence if it's because of COVID-19. So it's really important to note that you still cannot be away for more than 12 months. So when you read this document, what it basically is saying is, like, if you've exceeded, you can have your normal 6 months outside. No one questions that. You don't have to give a reason. But if you've gone over the 6 months and you're less than the 12 months, so in between 6 months and 12 months, in some cases that can be because of COVID. Like, we will accept that as the reason, but you do have to show them what the reason is. And it's not always straightforward, because normally what they talk about is things like travel restrictions. And if people have been ill themselves, or family members have been ill and that prevented their travel, that's covered in the guidance. But what the guidance doesn't say is, it doesn't say that if you chose to be away because you left because of your employment situation, or if your employer allowed you to work from overseas remotely, because lots of people have done that, it doesn't cover that situation, or it doesn't explicitly say that you can do that. And so that might be a problem for some people. I mean, I think what I would say about the guidance is it is just guidance. So when you're applying, or when you apply for either pre-settled status now, or if you apply for settled status in the future and you've had a longer absence because of COVID, you can always make your case to the Home Office. And it's not that the guidance is the absolute law on what happens. It's just the guidance document, but it shows you that it might be tricky for, in some cases, for people to be outside. If you can hear some drilling, I apologize. Someone apparently in one of the flats in the block that I live in has decided that now's the right time to do some drilling. So I hope that you won't get lots of noise on the microphone, but if you do, then please accept my apologies for that. So I have talked to lots of people about being absent because of COVID, and what I would say is it can be really complicated, and it will always be about the individual circumstances. So it's just something to be aware of. It does affect people, but I think that we'll know more in time about how this situation will be dealt with. So that's really all I'll say about continuous residence. We may have more questions about that and how you show that you've been resident in the UK. I won't spend much time on the criminal declaration because it's an extraordinarily complicated area of the law. But just to say that the idea of the declaration, if you're over 18, you'll be asked to declare any criminal offences that are still live. And the idea of that is that the withdrawal agreement allows the Home Office to refuse status to those who are the most serious offenders, and the UK says if someone's persistently offending in the UK, then we have the right to refuse status to that person. So that's the reason there's a declaration there. So it doesn't mean that if someone has a minor criminal conviction that they will be refused, not at all. But it is a requirement to make an honest declaration. I would say, I mean, generally, like the cases where someone has criminal convictions and which resulted in prison sentences, they are always the most complicated cases. It's probably worth speaking to someone before you apply to understand the position, if that applies to you. Obviously, we hope it doesn't apply to many people. So that's the criminal declaration, but I won't spend any more time on that. Once you've made your application, the Home Office takes it away and that they process it. Now, I've already had one question about the length of time the application takes to be processed from a written question I received in advance. So I'll sort of cover that. But the general point to make about processing time is that there's no set time of how long it should take. The Home Office publishes a guidance or a website with a bit of guidance on it, and it says, well, we can make the decision very quickly within a few days, or it can be made within about a month if it's straightforward, or it might take some more time if it's a bit more complicated and things like that. They say, well, for example, I've just talked about it, if you have a criminal conviction and we have to look into that, it's going to take us more time to understand your background. If you're not from the European Union yourself and you're a family member and the Home Office has never assessed your relationship to the EU sponsor, then that will take a bit more time. So there's situations where they say, this is going to take us a bit more time to process. But it doesn't mean that because you're not in one of those sort of categories where it takes longer, it doesn't mean that you'll get a decision within a couple of days. People will experience a few months of processing, I would imagine, these days. It also fluctuates depending on how many people are applying at any one time, because the Home Office has a team of caseworkers working on this, but if one month they might get 100,000 applications, next month they might get 150,000 applications. So inevitably things can take a bit longer. It's nothing to sort of worry about if you haven't heard within a couple of months. That's not a problem. As long as you've made an application and you get a letter when you make an application, it tells you, it's called a certificate of application. As long as you've got the certificate of application, then you're fine. And that means that you've got an application that will be processed. So it's important not to panic or anything like that. But after they've processed, you will be told what the outcome is. Now, as I said, like there are some cases that get refused, but it's very, very small amount compared to the amount that get granted. So in terms of grants of status, you will be given pre-settled status or settled status, and hopefully you'll get the right outcome for yourself. So obviously, if you get settled status because you have 5 years, perfect. If you get pre-settled status because you've lived in the UK for less than 5 years, perfect. If you get pre-settled status but you've lived in the UK for more than 5 years, that's not the right outcome for you. And you have to think about whether or not you can challenge that outcome. And it will depend on whether or not, on the reason, because usually what the Home Office would say is we didn't have enough evidence to see you living in the UK for 5 years, so we have to give you pre-settled status. And so if someone came to me with that outcome, I would say, well, do you happen to have any more evidence of residency that we could put forward in a new application? And if that person said, yes, actually, I've found a box of documents since I applied. And I would probably say, well, just make a new application. It doesn't cost any money and you can get settled status, because that's what that right outcome is for someone in that situation. If someone said, look, I gave everything that I could to the Home Office, but they still don't believe that I've been here 5 years, that person probably will need to, if they want to challenge the decision, would probably need to challenge it in the immigration tribunal and put their case to a court. And so there's different approaches. If you get pre-settled status and you think you should have had settled status, there's different ways of approaching it. Or if you really don't think you're going to get settled status because you don't have any documents, then you'll have to wait until you have enough documents to show the 5 years. So it does depend in that situation. If you get settled status, that is permanent, the permanent right to live in the UK. So you don't have to do anything else to stay here permanently. The only thing you have to do two things actually. One is you can't leave the UK for more than 5 years in one continuous period. You have to stay here. Well, you cannot be absent for more than 5 years once you have settled status. So that means traveling back at least once every 5 years, and don't commit any criminal offences because the Home Office will take the status away. So that's pretty straightforward if you have settled status. If you're getting pre-settled status, then you still have to comply with that 6-month residency rule until you are granted settled status. Okay, so you have to maintain your continuous qualifying residence when you're in your pre-settled status period. And then once you get to settled status, you can then have the absence of up to 5 years away from the UK. So different situation depending on which status you're granted. And also, as I've said, with pre-settled status, you have to make a second application to convert the pre-settled to settled status in the future. So it doesn't happen automatically. Okay, so that's what the status is. I think people will probably be aware, excuse me, that status is issued digitally. It's not, there's no biometric card. You don't get an ID card which says settled status or pre-settled status if you're from the EU. If you're from a non-European family member, you may get a residency card. But if you're from the EU, you're going to be given digital status, because the Home Office didn't want to issue 4 million ID cards to EU citizens. They said, no, we have an online and a digital status proof, and that's what people are expected to use. So that's one of the more controversial aspects of the scheme. There's been a lot of discussion about whether this is the right approach. There's been lots of political discussion about whether this is the right approach. All I can say really on that is I fully sympathize with why people might want an identity card. I see very strong arguments in favor of that if people choose to have one. But at the moment, the status is digital, and the Home Office is unlikely to change that approach. They have resisted any attempts to change that approach. So I think whilst people, it's good if people campaign to try and get an ID card, the reality is that people also need to be able to use their digital status. And that means learning how to log into your status. It means seeing how you access it and how you use it, because from the 1st of July, onwards, people will have to be able to access that status, because at the moment we're in what's called a grace period, where the employers don't need to check your status, they can just use your passport. But from the 1st of July onwards, employers are going to be checking status, landlords check status, the NHS will be checking status, and so people really need to be able to log in to see what their status looks like. So if you haven't done it already, try and do it. There's a link in the letter that grants the status, has a link in it. You can use that. It's on a gov.uk page. You can Google, it says there, view and prove my status. Have a look at it, because it's really important that you can access it. Okay. just because I want to move to questions fairly soon. So I'll just briefly cover missed deadlines. Please don't miss the deadline. If you have family and friends, please tell them not to miss the deadline, because what happens is this, is if you miss the deadline, then for a period of time, whilst you're trying to sort this out, you're going to be unlawfully resident in the UK. And that means you're not able to work. That means you're not able to travel in and out the UK. It means that you wouldn't be able to claim any benefits from the DWP if you needed to do so. It's just a really difficult situation to be in. You can still apply late, but you have to tell the Home Office why you've missed the deadline. They have to accept that it's a good reason, and then they have to process you, which will take some more time. And all this time, like I say, you don't really have any rights. So it's a really difficult situation for people to be in. So to avoid that, meet the deadline. We accept, I mean, it will happen. People will miss the deadline. It's inevitable. Not everyone knows about the scheme who needs to apply. A lot of the work that myself and no doubt embassy colleagues will be doing after the 30th of June is trying to help people to resolve this situation. And we're here to do that, and we will do that. But we don't want people to be in that situation. And that's why the deadline is so important for people to make. So I'm going to pause there because I want to move to the questions, and everyone's listened to my presentation for long enough. In the presentation that will circulate, there are some links to some useful documents. The Commission has written a number of guidance documents, like leaflets about the scheme that are available in all the EU languages. So they're really useful guides. There's some information about organisations who can help apply to the scheme. So that's in the presentation, but I will stop that for now so that we can dive into the questions. So I have questions that were submitted in writing, and I can see that people have been very good and active in the Q&A box as well, which I will take a look at. So what I'm happy to do, shall I just dive straight into answering the questions? We don't need to take a pause. Yes. Do it. Yeah. Okay, yeah. Great. So what I'll do is I'll work through both the Q&A and the documents, the information or questions I received in advance. So I'll take the first one in the Q&A from Maria here, which says, if you have indefinite leave to remain in the UK and you move away for a while, can you come back? Does it expire? So the answer is, well, it's true. Both of those comments are true. Yes, it will expire at some point, and yes, you can come back as long as you come back before it expires, is the answer. So this is something that's really crucial for people to understand. If you have settled status under the settlement scheme, that is indefinite leave to remain. It's a new type of indefinite leave to remain that the Home Office created specially for the settlement scheme. So if you have indefinite leave to remain as settled status, you can be away from the UK for up to 5 years without losing it. It will not expire within 5 years. And as long as you come back, you can reset the time, and then you can go away again, and you can have another 5 years outside. So it doesn't expire as long as you never spend more than 5 years in one go outside the UK. If you have indefinite leave to remain from the past, from a historical grant that may have come many, many years ago, then that type of indefinite leave to remain will expire after 2 years. If you are away from the UK for more than 2 years, you will lose it. And in that situation, you may not be able to get it back. So this is one of the reasons why I say to people, if you already have indefinite leave to remain, yes, you don't need to apply to the scheme, but you give yourselves an additional right if you do apply, because you can be outside for up to 5 years if you make an application into the scheme. But if you choose not to make your application into the scheme, the settlement scheme, and you just stay with your old type of indefinite leave to remain, you can't be away for more than 2 years. Okay, so that covers, hopefully that covers the answer to that question. I've had a question, this is one that was submitted in advance from Angela, who asked about a settled status holder who wants to apply for British citizenship. So there is a brief slide on the presentation about citizenship, but really what it was sort of saying is people with settled status are eligible to apply to become British citizens if you want to. No one has to become a British citizen. No one should feel forced into doing so. But if you do want to become a British citizen, you must have settled status. You can't do it when you have pre-settled status if you're an adult. So you have to wait until you have settled status. And then there's another set of conditions that apply to becoming British. I can't really run through them all now because they're complicated and they're long, and we'd have to do another session entirely, to be honest. So, but the question here is about residency, because the becoming British has more strict residency rules than the settlement scheme does. And so the question here is, if I want to become British, but I've been away from the UK for the last 10 months, because of COVID-19, can I still apply? And the answer probably is no at this point in time, because what the Home Office would normally say for naturalising as British is you can have in the last year. So if you apply today, you work back, you look at least a year. You actually have to go back 5 years at least. But in the last year, working back from the day you apply, you shouldn't be more away from the UK for more than 90 days, so 3 months effectively. But if you have been away for more than 3 months, we can sometimes apply discretion to your situation if you meet the policy on applying discretion. Now, that does include the policy on allowing for more absences than 90 days, does include the being away because of the health pandemic, but that is only if it's up to 180 days, it's included. So obviously 10 months is beyond that time. There is an additional discretion policy about exceptional absences that maybe go over 180 days. But the fact that they haven't included the pandemic in that exceptional criteria means that they probably don't expect to apply that if you did it with 10 months of absences. So I would be extremely cautious about trying to apply for citizenship if you had 10 months of absences in the last 12 months before you apply. I think that really the Home Office is likely to say no, and obviously you'd lose the application fee. You wouldn't lose your settled status, you would stay there, but you don't want to lose the fee, of course. So I'll go back to the Q&A. So we have Marius says, if a Greek citizen who has received settled status would like to marry a woman who is living abroad, United Kingdom, living away from the United Kingdom, Greece, Macedonia, and has never been to the UK, is she eligible to apply for a visa based on the spouse's immigration status? So obviously, Marius, you've picked up on the fact that the marriage date is going to be after the 31st of December. So the immediate reaction is, well, no, they cannot be sponsored under the settlement scheme because the marriage took place after the date that they tell you it has to take place by. But if someone came to me with that situation, I would ask them, how long have you been in the relationship with that person before? Can we show that you've have a durable, serious relationship with this person before 31st or by 31st of December? Because we might be able to argue that you should qualify, or they should qualify for sponsorship under the scheme as an unmarried partner. So I'd look at that first. But if I decided that it probably, or if it looked like they wouldn't be able to meet the conditions for the unmarried partner element, which the Home Office says, oh, we think you should have been living together for 2 years, or we think that there should be something else to show you're in a serious relationship. They give an example of a couple with a child together. So they can't set a definitive sort of set of circumstances, but they will say, we want this to be serious. If you met someone 3 months ago, 6 months ago, because 3 months ago is still about the 31st of December, but let's say you met someone 6 months ago, at the 31st of December, you would only have known them for 3 months. And so the Home Office is not going to accept that's a durable relationship at the 31st of December. So that's how I would start my assessment if someone came to me and got married recently. if I decided, or if the outcome is that they couldn't sponsor their partner, their now spouse, as a durable partner under the scheme, you can still sponsor them under a different part of the immigration rules. There's another set of rules that apply. It's just that the reason people wouldn't want to use them if they can avoid them is that it's expensive. It costs thousands of pounds. The person has to show certain criteria. The sponsor in the UK has to show that they have a certain level of income to be able to sponsor. So you don't want to use that route if you can use the settlement scheme, but not everyone will be able to use the settlement scheme because of the way that family members can be sponsored. Okay, so if you're in that situation, you would probably want to take some advice from someone in my kind of role to try to understand whether or not the settlement scheme there's any option, and if it's not an option, you need to know about the other immigration route to sponsor the spouse. Okay, I will dive into another question I received in advance. Again, this is from Maria, who said, I have indefinite leave to remain in the UK, and is asking whether I need a biometric card, and if so, how can I get it? So you cannot get a biometric card as an EU citizen. As I said, digital status under the settlement scheme there is no ID card for the settlement scheme. In principle, you may be able to get a card. If you have indefinite leave that's the older style, you may be able to apply for a card, possibly. I'd have to check whether or not EU citizens are prevented from getting a card, but there is sometimes a way in which you can do it. You can change if it's in a passport, you can say, well, I'd rather have it as a biometric card, and you can apply, but you have to pay for that. But if you're under the settlement scheme and you have indefinite leave settled status, you cannot get a card. Okay, and there was a second question from Maria, which was, her sister has pre-settled status, and when she made the application, instead of using the date she arrived in the UK, she used the date of employment, which is a year afterwards. Can you please advise how we can update that date and address? So essentially, what your sister will need to know is when did she actually arrive in the UK? What was the date? 5 years now, so she's already got pre-settled status, so she's fine at the moment. She all she needs to do is apply for settled status at the point when she can prove that she's been in the UK for 5 years. So if she's got lots of evidence of that first year in the UK, she can apply if she's got the 5 years. If she doesn't have very much evidence, then, and the Home Office is taking her residence from when she started work, you might have to wait until she's got 5 years from the date she started work. It just will depend in that situation about what she can prove from when she actually arrived in the UK. Okay. Okay, back to the Q&A box. So we have Demetrius. Good afternoon. Many married couples consisting of a UK and an EU citizen are inquiring as to the restrictions on staying in excess of 90 continuous days in the EU or the UK, especially if they are pensioners and would like full flexibility of where they would stay during the year. Okay, so this is obviously what we're talking about here is essentially sort of the mobility about obviously if you're an EU citizen and you have settled status in the UK, then you have full flexibility as long as you don't exceed 5 years outside the UK. So that's good. If you're a Greek citizen and you don't, for some reason, qualify under the settlement scheme because you've not been living here before 31st of December, then you're restricted to visiting the UK for actually 6 months in any 12-month period. So 180 days you can spend in the UK without needing to apply for a visa as an EU citizen. That's what the UK has agreed. If you're a British citizen going to the European Union, you can only spend 90 days in any 180 days as a visa-free citizen. And that's because that's what the Schengen rules are. So what you have is you have a slight disparity there, because if you're a British citizen, you can go to the EU for 90 days in any 180 days. If you're an EU citizen who's nothing to do with the settlement scheme, you can visit the UK for up to 180 days, basically. Why is there a difference? The difference is because the EU has a rule on being able to visit for 90 days under the Schengen arrangements, and the UK immigration system allows visits for 180 days. So what the UK chose not to do was to limit European visits to 90 days. They probably could have done that under the trade agreement, but they chose to keep it as the standard 180 days that they offer to anyone else from any other country in the world. So it's just it's a more, I guess, a more generous approach from the British side of things than the EU have stuck to their Schengen arrangements, and that's why there's a difference. So for British citizens, it will probably feel feel hard done by, but that's part of what the end of free movement has created, as far as the ability of Brits to go and live in the EU freely. If you want to stay longer in any member state as a British citizen, then you have to look at the individual rules of that member state, because you'd need to probably apply for some kind of immigration permit for that member state that you want to spend more than 90 days in. So obviously very, very complicated, but it does mean that it means that there is less, a lot less flexibility than there has previously been. And that was an intention of the UK government by ending free movement. That's what they wanted out of the Brexit situation as far as immigration is concerned. So that's where we are today. Unfortunately, some people will feel that's regrettable. Some people will support that position potentially. So I'll carry on with the Q&A. So Marius says, if someone got pre-settled status based on her parent status and is 17 years living in Greece studying primary school, may she be eligible to apply after 1 year to study in the UK and eligible for a home fees to get a student loan? Right, okay. Student loan questions are, I'm afraid to say, horribly complicated. And it does depend on, there's two elements to being granted home student fees and student finance. One element is the status that the person holds, the immigration status. So in principle, pre-settled status and settled status are qualifying statuses to get home fees, and some cases get student loans. But there's also a residency element. So where have you been living usually it looks at the 3 years before you start the course. So which country have you been living in? And there's actually different rules for pre-settled status to then settled status. It isn't my area of expertise, so I'm not going to be able to say any more than that. But clearly what they would need, what this young person would need to do is check on the position, because of their residency has been in Greece rather than in the UK, and how does that impact on their ability to get a home fee. So they'll need to check with the university whether that is going to be available. They obviously have the immigration status that qualifies, but the residency may be the issue here. Okay. Okay, I'll dive back to the questions that I received in advance, and we'll have one from Mario here, who was asking about the absences, the continuous residence rules that we covered in the presentation, and has said they're aware of the 180-day rule in the 12 months, and they left on the 23rd of June and came back in August. This is 2020, so have had 68 days. And so what they're asking is, so I think I have 112 days left until June 2021. If I essentially what the question is does my 6-month time reset once I come back, or every June, because that's when I left the UK initially. So once I come back, can I reset the 180 days because it's after 12 months? And I think if you were present in the part of the presentation I talked about, is unfortunately you have a different sort of interpretation between the UK and the EU. And so the answer is no, you can't just, at no point, according to the Home Office interpretation, and bear in mind that the Home Office is going to be the initial decision maker here when you apply for settled status, is if you, I mean, I'm assuming that you've got pre-settled status, because if you have settled status, then there is no 180-day rule. You can have up to 5 years. But if we're talking about you in your in a pre-settled status period, then you need to think of it as, I need to look at any 12-month period. So you can't, there's no cutoff point. It's not like so June, everything between June 2020 and 2021 is counted in one period, and then June 21 to 22 is in the next 12-month period. The Home Office doesn't see it like that. They will say, we'll add anything together from those periods. If anything that falls within a 12-month period can be added together. So you do have to look at your situation if you're away from the UK for a long period of time, and you cannot just reset the 12-month period according to how the Home Office interprets it at the moment. Okay. So we'll come back to the Q&As. It says, I have pre-settled status. Assuming your mum comes to the UK with a family permit and applies for pre-settled status, how long does she need to stay in the UK after applying for pre-settled status? Can she come, apply and leave again and come back in 3 months? And again, aware that you have to have 5 years of qualifying pre-settled status in 6 months. But how can they find out if someone is away for more than 6 months or less than 6 months? How do they know? So obviously, I mean, as you've pointed out in your question, if someone comes in and is granted pre-settled status, then goes away for 3 months and then comes back, they haven't exceeded 6 months, and so they will carry on with their continuous residence. So that's fine. In terms of how does the Home Office know how long people have been in the UK or not, the application asks you to self-declare. It says, when you apply for settled status after the 5 years, it says, are you making an honest declaration about your residency in the UK? Are the documents that you're giving us, do they show the correct residency? So you're actually just asked to self-declare. So I don't know whether the Home Office would be able to identify whether someone who had been outside 7 months in a 12-month period, if they would be able to identify that from things like passport or immigration control. I don't know. I think it would probably be tricky, but that's not the point, because the person is supposed to make the correct declaration for their application, and that's what you have to remember here, is you're being asked to make an honest declaration. It does happen sometimes that the system thinks people are in the UK when they're not. So if you're working remotely from overseas, then the system might say to you, well, we can see your national insurance number is active, therefore we think you're in the UK. In that situation, you shouldn't necessarily accept that you're being offered status, because it's not the correct situation. That's not what is happening. They're just saying, this is what we think is the situation. Can you confirm your situation? So you are being asked to make a declaration when you apply. But obviously, as you said, coming in, getting pre-settled status and having 3 months away is not a problem, because it's still within the 6 months. I think I'll pick up on this good question here about what happens if you have settled status, but the passport you used expired and you've renewed one. How do you link your new document to your application? So if you have settled status, then you've been granted, so your application has been approved. Well, what I think we're talking about here is the online profile. So basically, how do I link my new document to my online profile, because my digital status is connected to the document I've applied with? And the answer to that is, in most cases, what you do is you log into your digital status, and there's a function in there that says update my identity document, and you can go through the online process, and you take a picture of your new passport and that gets uploaded, and then the idea is the Home Office will change your digital status to the new document. Okay, so that's the way it's supposed to work. It doesn't work every time. There are some situations where it cannot be updated, unfortunately, at the moment for various reasons, but that's what should happen, and most people can do that. If you don't do it, if you forget or you weren't sure about it, then it's not like if you traveled outside the UK and you didn't update your status with your new passport, it's not that you're not going to be allowed back in the UK. You don't lose your status or anything like that. But what could happen is it might become you might have a bit more of a delay getting back into the UK, because obviously your status is linked to an old document. And so you may have to establish with a border force officer what's happening, why you have a new document. I mean, I think the thing is, we don't really know about this at the moment, because at the moment, we're still in the grace period, so none of these issues have really come out yet. So we won't know what the process is at the border until the 1st of July. Then we'll see if people have a problem because they haven't updated their status. But I think the key message is you don't lose your status. You're not going to be trapped outside the UK. It's just possibly it might take you a bit more time to re-enter. And then what you would do is update your document, because you then realise that you needed to do it, and then life will become a lot more smooth again when you cross the border. Okay, I will. Excuse me. I'm going to take another question I was sent in advance. I think it's from Thalia. Who says, I have settled status and I would like to keep my parents in the UK for a year to assist you with childcare. Your mother is working back home, presumably in Greece, and they were planning to come before Brexit, so they could apply to the EUSS independently, so coming before the 31st of December. But because of COVID, we're not able to do so. The flight, unfortunately, was cancelled. So they've entered in the beginning of January. And then, so what you've done is you've applied to the EUSS for them as parents wanting to join their child, but this is in the middle of July, and you haven't had a response yet. And you've said, should I stop waiting for a reply and apply for a 6-month family visa? I know they can stay initially for 6 months as visitors without a visa, but I would need some form of right to stay in the UK for the next 6 months. Yeah, so you've identified a couple of very crucial points there, and I think you've made, again, if you picked up in the presentation, one thing that I highlighted was that family members who come to the UK from the 1st of January onwards cannot apply into the scheme if they're here as visitors, which is what I think is what your parents have done, or what your mother's done for sure. So that is not going to be accepted. Assuming that the Home Office applies the rules as they've written them, that application won't be accepted, I'm afraid, because the rules specifically prevent someone here applying as a visitor. So what's happened is your mother has, or parents have entered as visitors, so they've got 6 months. But what you've got to bear in mind is you cannot extend that 6 months. You can't apply for a family visa for another 6 months. There isn't any type of visa to apply for. So they will have to leave within these 6 months. I mean, the Home Office, sometimes they do make decisions in the settlement scheme that, to me, don't make sense in accordance with the rules in terms of granting. So they have a live application. My assumption of the live application is that it's not going to be accepted because of the visitor clause. Strange things sometimes happen. So I'm not going to necessarily say it would never be the case, but I don't think it will be. If that is the case, then what they would have to do is they'd have to leave within the 6 months that they entered, because they've come in as visitors and they don't want to overstay that 6 months. The problem is it's quite difficult. It may be difficult for them to come back in, because you can't, with a visit visa, once you leave, it doesn't reset, and you can't just come back in for another 6 months because you've left. Because what the Home Office looks at with visiting is to say, well, is the person trying to live in the UK by using visiting visas or the visiting rules? And if they see someone who basically spends 6 months, leaves, and then tries to come back in for another 6 months, then they'll prevent them from doing so. So with your parents, it's a bit of a tricky one. And you could obviously apply for them to be sponsored under the scheme as a dependent parent to join you in the UK if they were doing it from outside, but they would need to be considered to be dependent. And I don't know if that's necessarily the case. So it's a bit of a tricky situation, I'm afraid. So, and it may not have a resolution where your parents can stay for the whole year. That's the problem that they have. And unfortunately, even though people were prevented from coming to the UK because of COVID, there's no concession that's been accepted by the Home Office. They could have created concessions to that, but they haven't done so. They've kept the 31st of December as the hard cutoff point for residency. So I'm sorry, that's not the best news, but you obviously need to understand the actual legal situation, and it's very important that we're clear about that with your parents. So they are, at the moment, on a 6 month sort of ticking clock, and there isn't a way to extend that whilst they're in the UK. Okay, so we have another question from Marius, who says it will definitely be the last question. If I applied and received pre-settled status in early February 2020, but I've been outside the UK during this period, living in Greece, lived there more than 1 year outside the UK, can I apply again for pre-settled status and get a new date of pre-settled status to not break continuous residency? So unfortunately, the answer to that is no. And the reason is because obviously you left in February 2020, so you're outside for over 12 months, and that always breaks continuous residency unless it's to do with military service. And if you won't lose your pre-settled status, you're not going to lose the one you already have, because actually that's only lost if you're away for more than 2 years. There's a separate rule to do with that. But if you came back to the UK and you said, and you tried to apply for new pre-settled status, and you said to the Home Office, right, so I was here in February 2020, I realize I've broken my continuous residence and I've come back in March 2021. Can I have a new grant of pre-settled status? What they'll say to you is, well, no, because you've broken your residence and you cannot begin a new period of residence after the 31st of December, because that was the cutoff date to begin a period of qualifying residence. So you've broken your connection to your one that did begin before December, but you haven't started a new one before 31st of December. So we can't give you any new pre-settled status. We're not going to take your current settled status away. You can have that for 5 years. But it does mean that at the end of that, you cannot get settled status because you've broken the residency. So this is, again, one of these very, very harsh impacts of the COVID situation, which will affect people. It means that they might not be able to get settled status in the future. So it's very difficult for people, and to an extent, because it's such a, the health pandemic was such an unprecedented event. It's not very satisfactory to say, well, people just lose their right to settled status, but that's the way the rules are written at the moment. So it would take a concession from the Home Office to change those conditions. So sorry, again, it's not something you want to say, but it's the reality of the way the rules are written at the moment. So let me just pick up on another one. So we have an anonymous. The applicant must not have been absent for more than 6 months. Does this period start and end with every travel abroad? For example, if I travel to Greece on the 1st of June and return on the 1st of July, does the period reset and then start? So no, like you accumulate. If you have multiple absences, they accumulate together. And then, as I say, it's the whole 12 months. So if you had 3 months at the beginning of a year and then 4 months towards the end of that same year, or the same 12-month period, you'd be over 6 months, you'd be 7 months, so you would break the residency. So you have to be careful. If you have lots of absences, you need to keep a record of them. There's a question about remote working, but I think that question was probably posted before I explained the situation with remote working, which is the Home Office COVID guidance doesn't provide it as a reason to be absent for up to 12 months. So it's again unfortunate, probably not positive news for some people who've been able to work remotely. So Demetrius has said, how do I interpret a 5-year absence? Can I just show up in the UK for 1 day, for example? Yeah, that's how it appears to be to operate. What the withdrawal agreement says is, it says that someone would only lose their right of permanent residence if they are absent for more than 5 years. So if you turn up for 1 day in a 5-year period, then you haven't been absent for more than 5 years. So you haven't breached the right, sort of your right to hold permanent residence hasn't been broken. There's no other conditions to it. It's just written like that. As long as you haven't exceeded the 5-year absence, you keep your right of permanent residence. So yeah, so I mean that's how it's written. So until someone shows me something which contradicts that, that's how I believe it's written. And it's interesting because if you look at the Home Office rules for the indefinite leave to remain, that's not the settled status one, what it says is, so the one where you'd lose it after 2 years, what that says is that, well, a person doesn't lose old style indefinite leave to remain if they are not away for more than 2 years, if the purpose of their return is to settle. So basically someone can go away for up to 2 years and come back to resume their permanent status here, as long as they don't exceed 2 years, then they're okay. That's the old style indefinite leave to remain, not the settled status. But the settled status just says you don't lose it as long as you don't spend more than 5 years. So there's no additional clause about what your intention is when you come back and return for your 1 day. So that's how it's written. This question says, if you have made a mistake, how do you update it? I'm really sorry. I'd need a bit more context than that. I don't know what the mistake is. I mean, I don't know if it's in the application process or something else. So I'm sorry, I can't really flesh that out anymore without a bit more information. I'm just going to pick up on another question that I received in writing. I think it's the last one I actually received before the session, from Zacharias, who says that they did their masters in 2019 to 2020, and they've applied for pre-settled status in December 2020 using evidence showing that they were living in the UK between September and September. Haven't received an answer within 3 months, and you've tried to contact many times, but it sounds like you've had some bad consequences of not having a decision. You've lost some opportunities. It's very tricky. I mean, as I say, as far as processing times are concerned, there is no time that the Home Office has to deal with this. It's not like it has to be done within a month or it has to be done within X amount of days, and therefore it's really hard. These situations are really hard to force the Home Office to speed up an application, because what they will, their position to sort of give their perspective is, well, we receive X thousand applications a day and we're working through them as quickly as we can. And, within that sort of context, they would say, well, we can't, we don't know what people's situations is, so we can't necessarily prioritize one person versus the next person, because otherwise everyone wants to be prioritized. And so that would be how they would sort of address this. But obviously the impact on you has been very severe. I don't know really what to suggest to them, because, as I say, 3 months is it's a longer time than you would hope for, but it's not super long in terms of the process. So it's difficult. I mean, look, there is a complaints process. The Home Office does have a complaints process that you can go online and complain about UK visas and immigration. And so if you feel that something, you've contacted them a lot of times and no one's really helped you to solve your situation, then you can lodge an official complaint and they may respond to it. I can't say that they'll definitely resolve the issue, but if you feel that you have been, you haven't received the service that you feel is appropriate, then that would be the only thing I could suggest to do. But I don't know if it's necessarily going to solve your issue. I'm sorry to hear about the situation, but there's nothing, there's no magic sort of silver bullet that I can offer you on that one. So I have a question from Katharina about proving a dependent parent. Yeah, it's a good question, and it is. It's a little bit of a complex one, because at the moment, the Home Office, the process is that what they say is, when you're sponsoring a dependent parent to join you or to stay with you if they're already in the UK, then we will, for the time being, we will assume that your declaration of their dependence is enough. We don't need to see anything additional. That's how their rules are written. So the answer is, how do you prove dependency? Is you just apply for the parent, because the Home Office does the rest. They assume that the dependency exists. Now that will last up until the 1st of July, because on the 1st of July, the process changes, and the Home Office from that point onwards will say, no, we do want to see evidence of the dependency. So up until, for the next 3 months, if you applied, they would assume that the dependency exists without asking you for anything else. If you apply from the 1st of July onwards, you will have to prove it. How do you prove it? It depends what the dependency is. So if you are talking about financial dependency, so if you support your parents and either in the UK or abroad, then the Home Office would say, well, can we see some evidence of you transferring money to them? We need to understand their financial position, because they're only dependent on you if the financial support you provide them is essential to their living needs. So if they have enough money to live and you give them some money which doesn't make much difference to them, that's not dependency. So we need to know their financial situation. We need to know how much money. We need to see that you're transferring it to them. So that's how they sort of go about financial dependency. If you were talking about health reasons, it's a bit different. You would need to produce medical sort of information about why your parent needs your support and why they're dependent on you sort of from a medical perspective. So it does depend. I mean, every situation of dependency will be assessed on the actual facts of the case. Not everyone would be considered to be dependent, and it can be quite complicated to prove it. So it would depend. But essentially, if you are applying for a dependent parent, the advice would be, do it now whilst you don't have to give any real details or information about it, because it's more straightforward. If you do it from the 1st of July, you're going to have to produce more evidence. So that's dependent parents. It is one of those ones that's a bit of a complicated area. Okay, so I'm just going to keep going through the Q&A. So someone says, how do I prove I've been living in the UK for 6 months during my pre-settle status? What documents do I need to collect in order to apply? Again, it depends. The Home Office has a list. What I would do is go onto the gov.uk website, Google EUSS residence evidence, go onto that link, and you'll find the Home Office guidance, because it tells you these are good documents. It's not an exhaustive list, so you can use other things, but what it's saying to you is this is the stuff that is helpful for us to see. So I think it says things like council tax bills. It says if you give us 5 council tax bills, generally speaking, we will accept you've been here for 5 years. So it can be quite straightforward. The list has lots of different things on it, and it's just about your situation to see what's on there. But don't be discouraged if you don't have something on the list, is what I'm saying. You can still use other things. Okay, we have a question that says, if I have pre-settled status but am away for more than 6 months, should I apply for pre-settled status before should I apply before 30th of June? I think I've already covered this question, and as I've said, it depends. So if you've been away for more than 6 months in the 12 months without the absence being for an important reason, then you may have been considered to break your continuous residence, and so reapplying isn't going to do you any favors. If you've been away for up to 12 months for an important reason, and you've got pre-settled status, you don't need to reapply for more pre-settled status because you haven't broken your residence. So you would just apply for settled status when you get to your 5-year point, and you would then show for the period that you had the longer absence of up to 12 months, you would have to produce evidence of why that was an important reason. So it will always depend on the situation. But as I say, for someone who has broken their residency because maybe they exceeded 12 months or they don't have a good reason, they cannot start a new period of pre-settled status now because we've passed the 31st of December. Okay, so we have a question that says, if someone wants to come to the UK now, how easy is it to apply? And if they don't have a job? Yeah, it depends, I suppose, because again, this goes back to the consequences of Brexit and what the UK government's intention was, which is to change free movement law into something which where they have a system that you can come to work in the UK as a skilled worker, but you have to apply for permission, you have to have a job sponsoring you in the vast majority of cases. So is it easy? It's definitely not as easy as it would have been under free movement. So you basically have to be sponsored by an employer. So you have to find your job before you apply to come to the UK. And for some people in certain occupations, that might be relatively straightforward. But for some people, it's not going to be possible. The Home Office has put a skill level on the employment occupations that are covered by the visa. So if you're not at that skill level, or if your job isn't covered by the occupations that the Home Office approves, then there is no option to apply. So it just depends on what you do. But it's this is the consequence of free movement ending.
Dear Chris, let's proceed to the final question. There are so many questions. We'll try to do something for the other. Let's collect one last question, and to thank you very much for your commitment in supporting the Greek citizens.
No problem at all. Yeah, and I apologize that I haven't been able to get through everything. I mean, sometimes this takes a fair bit of...
Let's pick a final question.
Sure. I'll just, I mean, the next one on the list was from Georgia, which is, I think it's a topic that we've already covered to an extent, but I'll obviously just to read it out. It says, I've applied, I have pre-settled status from the 25th of September. I left on the 17th of March. Is my right of pre-settled valid or not? So, I mean, assuming, so what I believe is being said is that you've left on the 17th of March, 2020. We're now on the 24th of March, 2021. And I get the implication that you haven't been in the UK in any of that period. And if that's the position, then what's happened is you have broken the continuous residence. So the consequences of that is you will not lose your pre-settled status, because you don't lose pre-settled status unless you're away for more than 2 years. But because you have broken the continuous residence, because the maximum you can have is 12 months if you have an important reason. And if you don't have the important reason, then it's 6 months. But so you've exceeded the 12 months. So in the future, to try to get settled status, if you applied, the Home Office will say, you've broken your continuous residence by being away for more than 12 months. You didn't come back, you didn't start a new period of continuous residence before 31st of December 2020, which is what you would have been required to do. Therefore, you can't meet the conditions to have settled status. So that's the problem of what's happening because of COVID, is that people are breaking their continuous residence. You don't lose your pre-settled status in most situations, but your ability to convert to settled status in the future is not necessarily, I mean, it can't be done if the rules stay as they are today. Just the rules don't allow for it to be done. So that's the problem, I'm afraid to say, and you're not alone in having that situation. I'm sorry, that's a very negative one to finish on, but it is the reality of how the rules are written at this point in time.
Dear Chris, thank you very much for your contribution today. We have many questions that remained unanswered. We're collecting them, and we'll try to make a Q&A for the remaining questions. Thank you very much. I'm thanking all the participants. I'm wishing Happy National Day for tomorrow. Χρόνια πολλά, and all the best to everyone. Thank you very much.
Thank you very much. Yes, sorry, Happy
much,
National Day as well.
Thank you very much.
All the best. Bye-bye.